Might be your also. And one repetition was filed yesterday. It was not listed. Can it be permitted to be moved to demand?
Today,
Yes. It was filed already yesterday. Or some only.
is it registered
Yes, madam.
at 2 p.m.
Madam.
or after this list is over?
Yes.
May I please, your lordship, I beg to mention item number 10. It may be adjourned for today, my lord.
It may be list after vacation, my lord.
Definitely, there is no time. Na? Before vacation, there is no time. On request from the you decker.
My lord, I beg to mention one unlisted matter also.
What is that before vacation? But on Friday there will be no mention. What is it?
Tomorrow, that is IA, my lord. IA in RFA.
I in
RFA, reference first appeal.
better today. 2 p.m.
Okay.
My lord, I beg to mention item number 2, my lord. My lord, this matter is being dealt by Jamo, my lord. I've been instructed to my lord adjourn this matter, my lord, today and list
Out of
after-
station, huh?
My
Lordship,
Jamo is out of station and
Lordship, I am for the petitioner, your lordship. In fact, the case is covered case, your lordship.
Huh?
This is the case, covered case, your lordship.
my lord,
Covered is
So,
still run a standing council is
Is-
not.
Yes,
there.
yes, that is the,
my lord, the files with him, my lord. And also they've received the Parawaz Government Department, my lord. And till next, the listing, my lord, will file the
let them file without fail, your lordship.
my lord, that will do it, my lord.
Because several adjournment were sought.
After vacation, my lord. Deeply obliged.
Second week of November.
Deeply obliged.
May I please, my lord? My lord, I beg to mention item number 6, my lord.
6.
Yes, my lord. Taken consent from other sir, my lord.
Your name?
M. Doji, my lord.
N.
M. Doji, my lord. Matter may be taken after puja vacation, my lord.
Third week of November.
My lord, I have another mention, my lord. Item number 11, my lord. It may be taken after vacation, my lord.
Third week.
Obliged.
Lordship, item number 8. That I want to mention, Lordship. I have taken consent from the opposite party also, Lordship. That taken consent
With
from the
consent.
opposite. Yes, Lordship. And this may be taken after the vacation, Lordship. Item number 8, Lordship.
Your name?
G kata. Lordship. G kata, gumto kata.
Third week. November.
Lordship.
Your lordship, I would like to mention a pending matter. Kindly it may be listed for
AB.
yeah.
Anticipated bill.
No, your honor. Read petition.
WPC.
Yes, your honor.
Hmm.
WPC 310 of 2023. Pending matter. Kindly listed for tomorrow, your honor.
Is it urgent?
Yes, your honor.
Huh? Why? Is it urgent?
For
If it's not urgent.
admission hearing, your honor.
Then after vacation. After vacation.
Your honor, kindly.
Admission hearing is after vacation. Immediately after vacation. Next.
As per last order, I filed additional affidavit and incorporate the representation.
Additional affidavit filed by petitioner on 10/10.
Yeah, this representation was left in my main petition. As order, I filed it yesterday.
There being 6% on the part of the documents. তাহলে যাবে। Now, additional affidavit is filed.
Yes. I'm seeking for notice at this stage.
At this stage, my lord, notice may be smell.
Let's see if issue notice. Issue notice, huh? You are for
I am for my lord, one my lord, representing one my lord.
extra copy.
I'm appearing for
Then
three.
Two my lord.
So I'll take this.
You were appearing for three.
Three. Right.
Then two, issue notice to two, respond number two. Yes. By registered ready post.
Yes, sir.
This the third week of November.
Measurement. Here I am impugning my lord, transfer order my lord. That is 25/9/2023 my lord. Basically my lord, I am conscious that my lord, that in transfer order my lord, the very limited scope is there my lord. To interfere. Now,
So why you are moving?
my lord, I am on that only my lord. Very
Political.
my case my lord falls under that parameter limited scope my lord. Now within my lord 9 months my lord of transfer my lord, I have been my lord earlier posting my lord, I have been again transfer my lord. At this is my lord, my humble submission is I have filed representation my lord before the authority my lord at based on 5/10/2023 my lord. So my at
What
this
is the impugn order?
impugn order my lord will find
30.
page number 30 my lord 30. My lord, I am serial number 1 my lord. Now I have been transferred to my lord Daporism my lord. Now my lord, I have enclosed the documents also my lord. Earlier I was posted as SEPA my lord. Taking into my lord my medical condition my lord, I got a stroke my lord, brain stroke my lord. Taking into that account my lord, I have transferred here my lord. So to facilitate some
What are the medical documents?
medical document I have enclosed starting from my lord page number
Did
23
you
my
file any representation?
yes, I have filed representation my lord
What is that?
at page number 30 my lord.
30 is your impugn order, 31.
That time my lord, at this is my humble submission would be my lord.
Wait, is it disposed of?
Not my lord, not my lord.
Not yet considered. On
Not-
5th of October, you filed the representation.
Yes, my lord.
My lord, that's why, very shortly.
This is dated 25th of September.
Yes, sir.
No, my lord, that
Let him consider and dispose of this representation
My lord.
within how many days?
My lord, within
15
7
7 days.
yes, 1 week, within 1 week.
and till that my humble submission my lord status quo my lord. Otherwise my lord, this impugn order was issued on 3/10 my lord. Down below my lord, see page number 30 my lord, on 3rd my lord.
Status quo. Either returnable.
Within 10 days, my lord.
Within 10 days. No, notice negligible. Notice not like that. No, like status quo. Till the representation is considered and disposed of within a period of 7 days.
My lord.
Highly obvious, my lord.
My lord, this method may be, my lord, kindly listed along with connected methods which are fixed on 13, my lord, day after tomorrow. My lord.
Day after tomorrow, no.
Uh,
On Friday.
Yes,
Difficult, na? Hurriedly, no order will be passed. Mind it. I'll issue notice on it.
Lordship, then
Always on the last day, there is rush of this.
my lord, there are so many analogous methods. Man. This may be
But don't expect on Friday.
not on Friday, my lord.
Then
Observation may be, my lord. This may be taken up along with other connected
another
methods.
numbers, connected meter numbers.
Lordship, 307 of 2023,
307, 23,
311, 2023,
311, 23,
198, 2023,
198, 23,
185, 2023,
185, 23,
47, 2023.
47
Yes.
only,
47.
47. 23,
171, 2022,
20,
23,
hmm,
139, 2023, 6060, 2020,
6,
6060,
606,
60.
660, 23,
182,
wow,
2023. These are the cases.
so many.
Yes. Here, Lordship, in some cases, Lordship, affidavit have been already filed. Lordship. Here, Lordship, notice has to be issued. Because it cannot be taken up along with those cases, Lordship. Here we have
All
to
like
file
he
our
is seeking this matter
Sure.
along with number king area on 13.
Lordship, since in most of the cases, my lord, interim has been granted, my lord, my case also may be considered.
In other matters,
Yes.
the
In
interim
phase,
order. No
phase
interim order. We wait
So
till
notice is yet to be issued, Lordship. As my friend is not praying for issuing of notice also, Lordship. Now questions of considering the Lordship interim, that's what arise, Lordship.
my lordship,
Here are Lordship 11 cases, Lordship. Out of them, Lordship, in 3 cases, Lordship, interim is yellow. In rest,
3 meters interim.
interim are there, Lordship. But in rest cases, Lordship, interim have been denied, Lordship.
You serve notice last today.
yes,
Huh?
yes. And lordship, my lord, since
service.
the matter is being now taken up by the CBI, my lord, I may be this CBI may be, my lord, implemented as a respondent number 5, my lord, without filing
No,
application.
then you file I. Nowadays it cannot be by hand.
Okay.
Earlier practice is discontinued. CBI.
Yes.
The petitioner shall file an interlocutory application for implement of the CBA, Central Bureau of Investigation, as respondent number 5. You file I. On Friday will be taken up.
Okay.
Didi, aku CBA level.
Okay.
May I please, my lord? Here, my lord, the petitioner, who is a government employee, my lord, my lord, and completed, my lord, more than 20 years of service, my lord, has sought, my lord, serve a voluntary notice on, my lord, 29/6/2023, my lord, seeking, my lord, to avail the voluntary retirement scheme, my lord, under Rule 48A of the CCS Pension Rule 1972, my lord. And my lord,
The 3 months notice has been completed, my lord. Despite that, my lord, no response has been given by the,
That means your voluntary retirement request has not been accepted.
no, not at all considered. It has to be considered within a period of 3 months, my lord.
Hmm.
So if within the period of 3 months, it is either rejected or not considered, then it will be
That is
deemed
the rule.
deemed acceptance, my lord. The rule, my lord, I have mentioned in page
When
11.
did you make the request?
Request, my lord, on my lord, 29/6/2023, lords will
Page
find
number?
page 27, my lord. Page 27, my lord. Request has been made on 29/6/2023 to the my lord chief engineer, who is the my lord appointing authority, my lord. Permission for voluntary retirement from service. With reference to the subject cited above, I see such and such is hereby requested to give permission for voluntary retirement of my service as I want to work such and such, and I have completed more than 22 years of service in this department with effect from 30/9/2023, my lord.
Hmm.
And
You want to work in farming, entrepreneurship and social worker sector.
no, basically, my lord,
Election.
basically election, my lord. So at this stage, my lord,
Election, junior engineer.
at this stage, may I pray, my lord, is a covered case, my lord, may notice may be issued, my lord. There is an urgency, my lord, so may a fixed date may be given, my lord, after Puja vacation, my lord.
My lord, I am told that there is corruption case pending against him. He have not whispered about this case in his internet petition.
You submit on the next date. In the meantime, you file affidavit.
Yes.
On 9.
9th, my lord. Or
9.
my lord.
9/11.
Right.
Issue notice. People. You are for respond number 1.
For 1, 2, 3 are the
1, 2, 3, all.
Yes.
Then extra copy.
My lord.
Extra permission.
As soon as has accepted notice, extra copy of the petition along with the documents appended there to be furnished to
Winning. There is a.
within 2 days.
Okay.
Always.
Top, I going to representing all the respondents.
May I please, my lord. My lord, this writ petition is arising out of the, my lord, NIT. Notice inviting tender, my lord. Page number 24. Page number 24, Annex 3. My lord, here, the executive engineer, West Division, AP means Arunachal Pradesh Housing and Welfare,
Page number
24, my lord.
24.
Yes. This is tender, my lord. Issued by the respondent number 3, the executive engineer, Arunachal Police Housing and Welfare Corporation Limited. Within the Department of Police, my lord, the engineering wings have been created. And this engineering wings are executing some construction work, my lord. Therefore, this executive engineer has issued this NIT. My lord, in this NIT, may I take the page number 26, my lord. Page number 26. As per the NIT, my lord, the 4 government quarters are to be constructed in 2 different assembly constituency. 2 in the 14th Doimok Assembly constituency, and another 2 is to be constructed within 15th Sagale Assembly constituency. And here in page number 26, my lord, here this respondent number 3, he has only mentioned, my lord, only 14th Doimok Assembly constituency. But I am from 15th Sagale Assembly constituency.
Now, may I again take to page number, my lord, page number 31. Page number 31. This is a act passed by the state government, my lord, that Arunachal Pradesh district-based entrepreneurs and professionals incentives development and promotional act. This is an act passed by the government of Arunachal Pradesh. And as per this act, my lord, categorically the amount has been described. So more particular page number, serial number 2 of page number 31, my lord. Here above rupees 50 lakhs to 1 crore. The all registered contractors in class 1, 5, and 3 categories domiciles within the territorial jurisdiction of assembly constituency. Here, my lord, as per this provision, I am belonging from the 15 Sagale assembly constituency. I am not from the this 14 Sagale, 14 Doimok assembly constituency. Here, my lord. May I again take to page number 24, my lord. Page number 24. Here, 1, 2, serial number 1 and 2, these quarters is to be constructed within the 14th assembly constituency, 14th Doimok assembly constituency. Page number 24, my lord. And serial number 3 and 4, these two quarters are to be constructed at one Sagale and another one is at Mango, which falls within the 15th Sagale assembly constituency. But in the NIT, the respondent only mentioned 14th Doimok assembly constituency. That not have been mentioned at this 15th Sagale assembly constituency. But then I have this, there are two petitioners, my lord. They have participated in the tender process and they have been disqualified. Their tender has been rejected on the ground of that these two petitioners not belong from the 14th Doimok assembly constituency. But as per this NIT, my lord, 15 Sagale assembly constituency is to be reflected in this NIT. But that has not been reflected. Because of that, my candidate had been, my lord, rejected. So being agreed by this NIT, so my tender process, everything has been, my lord, rejected. Now respondent number 4 has been selected. By virtue of
tender has been rejected.
my tender has been rejected, my lord. Only on the ground of this, I have submitted the documents of the 15 Sagale assembly constituency as per the Entrepreneur Act 1915, my lord. So I have my tender paper has been rejected, my lord. So respondent number 4, who is from the 14th Doimok, have been allotted, my lord. So my submission report is honorable court, my lord, being agreed by that act of the respondent, my lord. So at that moment, my lord, notice may be issued to the respondent. Let them come with their justification. Why the 15 Sagale Doimok Sagale assembly constituency has not been reflected in the NIT, my lord. This is my submission, my lord.
Madam?
What's the
Yes,
issue?
issue notice. You are representing
1, 2, 3, my
1.
lord. 1, 2, 3.
1, 2.
1, 2, and 3.
1, 2, 3. Government executive. 1, 2, 3. Then 4 issue notice to respondent number 4 by registered telepost. List. 3rd week of November.
Yes, my lord. And extra copies, my lord.
Hmm?
Extra copies, my lord.
Extra copy.
Yes, sir. Of like, my lord.
Right, emails.
My please, your lordship. My lord, the case that I'm going to argue today is actually it is pertaining to a larger issue of government land allotments. Lordship, what the government does is they give allotment to people who occupy government land. It is even in the format of the land allotment applications also. So there is nobody in the whole of Itanagar who has not occupied the land before being given allotment. But what happens is, Lordship, what happens is that those which the government has decided not to give, they give eviction orders. So it has become a sort of practice, Lordship. In fact, Lordship, the land allotment rules also in the format itself, it is mentioned whether the land is occupied, till when occupied, since when occupied. These things are there. I can show, Lordship, from the land allotment rules, Lordship. Now, Lordship, coming to this case, Lordship, the petitioner's mother, actually, in 1993, was allotted a government quarter. She was a peon. The allotment order is at page 18. Since then, Lordship, the petitioner was staying with his mother in 1993. Page 19 is the type copy. Then thereafter, after his mother retired, in the same quarter, Lordship, his wife was given allotment. This is 2016, Lordship. Now this quarters, Lordship, was built. It's not even an RCC, it's Assam type, and it was built sometime maybe in the 1980s. Since 2016, they were staying there. But Lordship, the situation of that building is so bad that it is difficult for them to stay. So Lordship, near that government quarter, an RCC building was built, and for that which the petitioner had applied allotment, Lordship. First,
Did you inform the authority during that period?
Yes, Lordship.
Where is the?
Not by Lordship written, Lordship. Lordship may see page 75, Lordship. This is the situation of the quarter, Lordship.
Yeah, all right.
Lordship. So in 2013, he applied for land allotment. 2015 also applied. Government misplaced it. Finally, in 2019, he again applied. The papers are in page 23 onwards, Lordship. And in the verification report, Lordship, page 27, the distance from the quarter is 4 meters, Lordship. Now the allegation against me, Lordship, is at page 21, Lordship, saying that I have unauthorized occupation and illegal construction within the premises of the government quarter, Lordship.
What is that page number?
21, Lordship.
29.
21. The so-called notice, Lordship. Page 21. They have said that there is.
21 is a so-called notice.
Yes. Saying that unauthorized in the bold, Lordship, the grounds, bold. Second para. Unauthorized occupation and illegal construction within the premises of the government quarter. Now, Lordship, that government quarter, Lordship, does not have a wall, Lordship. The building which has been built, it cannot be said to be within the premises, as in because it is not bounded by any walls, Lordship. It is.
Are you still in service?
Yes, Lordship.
Where you are working?
I am working in the police department, Lordship. Now, Lordship, the problem is, Lordship, recently after this so-called notice, I had filed reply. It was rejected. Then I had filed appeal.
Where is there a copy of reply?
Replies, Lordship, page, Lordship, 40, Lordship.
40.
I have said in the reply that the construction is within the, it's on a jungle near the quarter. Then, Lordship, page 43 is the order, Lordship, rejecting my case.
Let me finish reading.
Yes.
You constructed an RCC building.
Yes, Lordship. Not within the premises, near the quarter, Lordship. Quarter has not been touched, Lordship. That is because the quarter is unfit to be lived in, Lordship, now. It is not only my case, Lordship. It is not only my case. Your Lordship, earlier when your Lordship used to say, your Lordship must have noticed these cases are, this is because, Lordship, I'll just show one thing, Lordship. This is the land settlement records rules, Lordship. This is the format of the land if you want a land allotment application. Lordship may see. The one that I have encircled, Lordship. Government itself recognizes, it seems, that occupation can be before allotment, Lordship. Otherwise, where else in whole of India will Lordship find this kind of requirement, Lordship? Now, Lordship, I have filed reply, my case was rejected.
What is the rejection order?
Rejection order, Lordship. First rejection order is page 43.
After hearing both sides?
Yes.
You reject.
Yes. Obviously, Lordship, they'll only say, since I don't have allotment, I'll only say I'm an illegal occupant. Now, Lordship, I filed appeal. Copy of appeal is also annexed, page 50 to 58. Then, Lordship, appeal was rejected, page 59. Basically the same grounds, Lordship, the rejection also. Then, Lordship, although the appeal was rejected in the month of August, I received the copy only in the month of September, Lordship. Now, Lordship, the reason that I did not come early after that is because, Lordship, there was a meeting between the district administration and the people who are affected like this, Lordship. So there was even, in fact, there was an announcement in the, there was a press conference also saying that further eviction will not be done. And one order was passed, that is Lordship, 4th September 2023, page 70, Lordship. It's not very 70.
64.
70, Lordship.
70.
Yes. What happened is, after this, Lordship, there was a meeting in between the district administration and the people who are affected by this kind of orders, Lordship. Then a meeting was held and it was decided that the members, page 70 is not very legible, so I have made a type copy, page 72, Lordship. This is 4th September 2023. Lordship. Here, as a result of that meeting, some committees were formed whereby they were constituted to prevent further encroachment, to report to the administration, Lordship, so that further encroachments would be stopped, Lordship. But saying that at that time, it was said in the meeting that further, those who have built already, further eviction would not be done, Lordship. However, Lordship, the estate officer acting on the dismissal of my appeal has requisitioned the police. This is page 64, Lordship.
16.
64. 64.
64.
Yes. Here, the estate officer, since my appeal has also been rejected, and the estate officer has requisitioned the police for
Eviction.
not eviction, but sealing of the building, Lordship. This is in the last paragraph, Lordship.
Problem in ejection, eviction, right?
Lordship, the last paragraph of this page, Lordship. By virtue of the powers conferred under Section 5(2) of the APP, eviction of UO Act 2003 in matter of refusal / failure to comply with the order of eviction prohibition number this in the matter of Director Housing versus versus Chao Hita Manche, respectively passed by the court of the undersigned as well as the appellate court. Hence, it is to inform you that sealing of unauthorized structure will be carried out on 9 October 9/10/2023. Now, Lordship, after this order was passed, the other persons, including myself, file a representation before the Deputy Commissioner. This is page 66, Lordship. It was to be carried out on Monday, Lordship, but before that, they approached the Deputy Commissioner saying that kindly recall
What is the
that,
present status as on today?
Lordship,
This was fixed on 9/10.
yes, thereafter we
Okay.
filed this representation. Representation was filed. Then Lordship, praying for recall of that order. Then Lordship, page 68 is the present status, Lordship. According to this, the estate officer has postponed the this act, Lordship, and she has said that since the Deputy Commissioner ICS is out of station and his return, the sealing of unauthorized building will be, which is fixed or which was fixed on 9/10, is hereby deferred.
Urban development.
My lord, the action of government ought to have been defended by my colleague. Anyhow, my lord, every appeal or any that the representation, the proceeding that held before the state officer was against the petitioner. In the appeal also is against the petitioner. Now we know, my lord, it is fact that there are plots of land which people occupy, and government has also a policy that the allotment is given to only to occupied area. This is ought not to Arunachal Pradesh, but this is the bitter truth. People first occupy, then seek allotment. This is the procedure. Now, at this stage, we would not wants protection for tomorrow.
Yes.
Because
I'm on that today.
yes, man.
Whether to be sued or
Harm to us, because the status quo would be maybe decided in merit, notice may be issued, and I leave this interim order up to your lordship, my lord.
Yeah.
The fact, definitely, my lord, if interim order
is out of station.
Lordship, that I have no instruction.
from the housing side, my lord, that's my stand. Rest, the government will defend their action, my lord, because a state officer
has failed in every forum.
Yes.
As a last resource, he has filed a C or C.
Yes.
He has filed this petition.
My submission, let have mercy on me, Lordship.
That's why obviously we understand the problem. That's why I'm not vehemently that was saying anything before this honorable court. We know the practicality of things that's happening in Arunachal
Delay
Pradesh.
by more days.
Yes, lordship.
Status quo, no? Till a returnable date. Returnable, you will find affidavit.
Yes. Extra copies may be served to both of us.
Yes, sir. Respondent, how many respondents are there?
Four, I'm for the four. Respondent one and two, one, two, three, Michael.
You are representing.
I'm for four.
1, 2, 3.
Two and three,
Four
Lord
you are
Sip.
representing. Four extra copy, requisite number extra copies we furnish.
By mistake, I have already given an extra
Within,
copy yesterday.
Today you furnish the copies.
Lordship.
Hmm.
Yesterday I gave 2 copies by mistake. So they should be counted as extra copy.
Status quo till the determined today, as on today. Notice na lagi. Highly English is different. 1, 2, 3, 4. Represented.
No, 1, 2, 3,
Madam.
2 and 3. I am for 2 and 3. Lordship.
2. 1 also. Include 1.
one,
Government.
Mr. Kamdu,
One who is 1.
Len.
Who is a standing council?
Mr. Kamdu, he is out of station.
Land management. Then issue notice to respond number 1.
Yes.
Justice service.
I have already
We are
serving
talking-
copy, Lordship. He's not here, but I've given to the
Justice
clerk.
service.
Already furnished.
Already served, Lordship.
Already served.
Yes.
So it is submitted that notice has already been served to the respondent number 1. In view of above, in the third week,
Yes.
third week of November, until then, status quo as on today, give the date, shall be maintained
Much obliged, Lordship.
in respect of the
RCC building of the petitioner.
No. Wait. The status quo will not serve your purpose.
Near government quarter number.
State issued by Secretary Capital number may be state. No. Stay, I think necessary. Stay of operation of that order.
Status quo will also do, man.
Yes, Lord.
Yes, okay.
That is enough.
In respect of the official quarter.
No, Lordship, the RCC building of the petition near government quarter is not livable. I'm not living there now.
Not near.
Near government quarter, C-70.
Property
Yeah.
which find mentioned in the impugned order.
Page 21.
Impugned order number DCICC 1701, page number 16, right from here. In respect-
Obliged.
My lord, this is regarding regulation of service, my lord. Here, my lord, we have filed our affidavit, my lord.
You'll file affidavit.
Yes, my lord.
You are for respond number,
All the respondent, my lord, 1 to 4.
all respondents.
Yes, my lord, 1 to 4.
Shall file affidavit. Fourth week of November,
For admission hearing, my lord.
your name?
Sonam Samu.
Huh?
Sonam Samu.
Chumu. Nam Chumu.
Ma'am, my lordship, we need some more time to file affidavit. ma'am.
To file affidavit.
Yes, ma'am.
You are for respondents number
All, ma'am, all the respondents.
1.
All.
All. Yes, learned counsel. This is seeking time to file affidavit in opposition.
My lord, here, actually case is very small and very clean also, and affidavit also is not required.
Without hearing the other side, without consideration of the case of the other side, it will not be justified, I think. You also agree.
That is, my lord, that is okay,
But,
but the record also is very clean, absolutely complete record. are
Without
there.
fail, next time. Say,
And
hard
just
week
pulling
of
me just
November,
for
hard week of
flex. Okay, my lord, most obliged.
Yes, my lord. Here, my lord, I am yet to receive instruction, my lord. I am
Failed
praying
to
some more
obtain instructions for respondents number
2, 3, and 4, my lord. I am praying
three,
sir,
four.
more time, my lord. I am praying more time, my lord, for filing.
Time to file
My
affidavit
lord.
after obtaining instructions.
Yes, my lord.
And who is appearing for others?
For once.
For one, you are government advocate.
Yes.
Yes, Santosh. So for time to file affidavit in the position. List. In the 4th week of November.
I will. Much.
Well, the parties have settled the matter now.
Okay, parties have settled the matter.
Therefore, I may be allowed to withdraw, my lord.
Who you what will do? Mr. Tapo.
Yeah.
Mr. P. Tapo, Learned Counsel appearing for the petitioners, clearly submits that the matter dispute involved in the instant petition has been amicably settled outside the court between the parties, and as such, under instructions of the petitioners, the matter may be treated as not raised.
Yes.
The respondents so have no objection. In view of above, the matter stands closed.
Yes,
or
close.
withdrawn.
Close. Deeply obliged.
Not
Obliged.
dismiss.
Yes, no, both will do, my lord. Nothing. Yes, obliged. my lord. If, leading counsel, Mr. B. Picha is out of station.
Out of
Lordship.
station.
Lordship.
Shall I go out of station?
So I'll seek for adjournment, Lordship.
You'll have filed the
Affidavit in
Those are
reply.
filed.
Pleading is completed.
in the second week,
Pleadings complete, Lord.
pleadings complete.
Lordship.
That is why it is in the admission column. The
After puja break.
after like at least in the second week of November.
Lordship. Much.
Counter affidavit not filed. Yes. Is it your matter? Item number 9.
Yes, my lord. I am for petitioner, my lord.
Counter affidavit. Service report in respect of respond number 3, please.
Madam, we have yet to receive the instruction.
You are for respondents number?
I'm for respondent number 2, madam.
Respond number 2. Pays for time to file affidavit in the position. You are?
1, Your Lordship.
1.
Yes.
I will file affidavit.
No, Your Lordship, the respondent 2 will rely on the.
You are
Secretary.
for 1.
Yes, Your Lordship. No, our affidavit will be suffice, madam. They can.
No, suffice.
Yes,
It is submitted that the affidavit contemplated to be filed by the respondent number 2 will be sufficient to be relied on behalf of respondent number 1. And 3, private respondent. 3,
Yes,
private
my
respondent. Notice serve or not?
My lord, that time, my lord, I have taken step upon second 2 occasions, my lord.
Then, in respect to respond 3 is awaited.
Latest I took step
You,
on 24
does the service can be done or not? He is an employee
PW.
PWD.
Yes.
Dusty service, my lord, as he's try to occupy on my lane, my lord. Dusty service will not be possible, my lord.
Then await service report, my lord.
Average service report. Then.
Yes.
You take time.
Yeah.
You cannot approve her, na?
No, my
He's upright.
Clearly counter
my lord. Interim order is there, my lord. My lord.
order earlier will continue till then.
High level.
May I please, my lord, last occasion, record was called for, my lord.
Record was called for.
Yes, disciplinary proceeding against the petitioner's file was called. my lord.
Record is received or not?
Lordship, I've received the records. I have received the record.
You have received.
Yes.
In a question filed by respondent number 2.
Here, my lord.
All have filed their affidavit, na?
Yes, Your Lordship.
My lord, here, my service has been terminated
Hmm.
without following the due procedure of law, my lord.
Were you a regular employee or contractual?
Regular, I'm regular employee.
Sure.
My lord will see the impugn order at page 27, my lord.
Number 12. The item number 22. 20 and 21. 2021.
Yes, my lord will find impugn order at page 27, my lord, annexure 1. Last page, my lord.
Last page number
27.
27.
7. Yes, madam. May I read, madam?
27, na?
27, yes, madam. Last page, madam.
What is it? 23. 24, finished.
24, 27, annexure 7. 27.
Annexure 7 is not here.
27, page 27, madam. WPC 437, madam. It might be
4 to 7, na?
437, 20, item number 20, my lord. First take up the item number 20, my lord. That is item number 21, I think.
437.
Yes, madam.
This is item number 20.
21, madam.
You are on 21. Page number 27.
Yes, madam.
Let me see.
May I read, madam? My lord, it is about 25th August 2023, my lord. In persons of the provision to CCR Rule 1965 and on the basis of Departmental Inquiry Committee report by dated 25/8/2023 and with the compliance of judgment order dated 10/11/2022 passed by the Honorable Guwahati High Court Itanagar branch, the service of Srimati Nada Dumi, ex-peon, is hereby terminated with effect from 28/5/2014, who was placed under dice known with effect from 28/5/2014 due to her prolonged willful absence from duty, madam. My lord, this.
All right, DP was drawn or not?
My lord.
Departmental proceeding.
Departmental proceeding. They have not proceeded any departmental proceeding, my lord. So, my lord, may I take, my lord, this order, impugn order, has been passed in person to the judgment and, my lord, an order passed by this honorable court, my lord. My lord will find that judgment at page 7, my lord.
Page number 7.
17, 17, my lord. 17. Annexure 2.
The statement directed to reinstate the petitioner back into survey, however, liberty is granted to respond to initiate press proceeding as may be permissible in law. The entitlement of all other statement for decision by the competent authority in accordance with law.
My lord, I will take some relevant paragraph of this judgment, my lord.
Page 12, no?
Paragraph
12.
yes, no. 12, yes, 11 and 12 is the relevant portion, my lord. And observation made in these judgments, my lord. I'll take some important paragraph.
Directed to reinstate the petitioner back. Who was the petitioner?
Same petitioner, my lord.
There was another round of litigation.
Yes, by this, I was in 2020, I was terminated, my lord. Against this termination order, I filed this writ petition number 147 of 2020, my lord. And by this writ petition was disposed of in my favor, my lord. Setting aside quashing the termination order, man, and respondent was directed to reinstate me, my lord. My lord, here, though they have reinstated, my lord, and my service was placed under dash nons, and after placing under dash non, present imping order is in pass, my lord. Terminated without any disciplinary proceeding, without any so-called notice, my lord.
In personally provision.
So, my lord, some
Terminated.
relevant
Terminated with effect from 28/5/2014.
Yes. I was absent for 5 years.
2014.
Yes, 5 years.
From 28/5/2014. This judgment was in the 10/11.
Yeah.
22.
22 years, my lord.
From back then.
I was absent for 5 years, my lord, since 2014, my lord. Then I challenged. Then they have, in 2020, they have terminated my service since due to my absence, my lord, because of my absence, my lord.
Was it under consideration in this judgment?
Yes, my lord. Therefore, I would like to take my lord to the relevant paragraph, my lord. Otherwise, this presents imping order is complete disregard to this judgment order, my lord. So, my lord, some relevant paragraph observation made in respect of writ petitioner and her absence from the service, my lord. So, I'd like to take, my lord, paragraph 4, my lord. Paragraph 4, my lord. May I read, my lord? Paragraph 4, my lord, page 18, my lord. The petitioner thereafter by letter dated 25/10/2015 informed the respondent number 2 about the treatment undertaken by her from specialized hospital. She stated that she was under treatment at AIMS Hospital, New Delhi, and was required to undergo surgery. For this reason, she was unable to join her duties since the year 2011 properly. Thereafter, respondent number 2 published a notice in local daily dated 13 March 2020, requiring the petitioner to join in her duty within the period of 7 days from the date of that notice, failing which disciplinary proceeding would be initiated against her. In response to the notice, the petitioner submitted her joining report, condonation of break in service, to the respondent number 2 on 19 March 2020, stating that in compliance to the notice, she has joined her service on 19 March 2020. She further stated that the reason why she could not join in service earlier was due to her illness, and she had undergone medical treatment at General Hospital 0, Hema Hospital Itanagar, M Hospital Delhi, and Lokmanya Tilak Municipal Medical College and General Hospital Sion, Mumbai. Since her health condition was better now, she was able to join her service, and she therefore requested that she be allowed to continue in her service by condoning the break in service. Thereafter, by imping order dated 24/4/2020, the petitioner was terminated from service under the temporary service rule. Although the petitioner submitted notice under section 80 of CPC to the respondent number 2 on 34/2020 through her engaged counsel, but as she was not taken back into service, she is before this court through the instance petition. And my lord, I'll take my lord to the para 9, my lord. Important, this is important, my lord, para 9. In that petition, I challenged again that I was not served notice without any disciplinary proceedings. My service has been terminated, and that too under temporary service rule, my lord. So para 9, my lord, will be important, my lord. Para 9, my lord. Article 300.
All right. 311(2) Constitution of India provides no person who is a member of civil service of the union or an all India service or a civil service of the state or holds a civil service post. Can be dismissed or removed for reduction except after an inquiry. He has been put on the charges against her.
Now here, my lord, what we have to look into is, my lord, whether my present termination order is as per the law.
This termination order was under challenge in the previous
Previous.
round of litigation.
Yes, my lord.
Now, what is your grievance?
Now, again, they terminated my service, my lord, by this impugn order, my lord, without any due process of law, my lord. And it is undisputed, my lord.
Where is that order? This 25(8).
No, 27, my lord.
27.
Yes, my lord. Is the
page number?
Page 27, my lord.
No, we debate for 28(5), 2014.
Yes, my lord.
This is dated 25(8).
Retrospective, they have given this termination retrospective effect, my lord.
Retrospective.
Yes, my lord. This is of the 25 August 2023, my lord. Now, my lord, here judgment, as per this judgment also, CCA rule is there, my lord. And as per the CCA rule, Rule 14 will provide for the disciplinary proceeding, my lord. And without following that rules, my lord, and violating the natural justice, my lord, they have issued this impugn order, my lord. And that too against the
CCS rule, relevant rule.
14, my lord. Rule 14, my lord. Rule 14 provides, my lord, for procedure for CCA rule 1965.
CCA.
Yes, 1965, my lord.
Really? Rule 14.
The procedure provides for imposing major penalties, my lord. Rule 14, my lord. Part 6, Rule 14, my lord. Yes, my lord, got Part 6, Rule 14.
Part 6.
Yes, Rule 14. So directly I'll take the sub rule 4, my lord. From sub rule 4, it will make clear, my lord. May I read, my lord? Sub rule 4.
That's what I mean. Too long. Sub rule
4, 14 of 4, my lord. Rule 14, Rule 14, Rule 4, my lord.
The disciplinary authority.
Yes, my lord. The disciplinary authority shall deliver or cause to be delivered to the government servant a copy of article of charges, the statement of imputation of misconduct or misbehavior, and a list of documents and witnesses by which each article of charges is proposed to be sustained, and shall require the government servant to submit within such time as may specify a written statement of his defense and state whether he desired to be heard in person, my lord. Here, this completely they have scrapped, completely they have not followed these provisions, my lord. And my lord, they have purported to be done inquiry, my lord. That report also has not been furnished to the petitioner, my lord. And that report has to be, need to be punished, my lord. That has also been not punished, my lord. And my
He
lord,
was not drawn up.
yes, article of
So
charges.
how they
Yes.
copy you for this?
Yes, my lord.
All right, madam, what do you say?
Lordship,
No inquiry, nothing.
The
was there.
inquiry was done, your lordship. Proceeding was done, your lordship. Earlier, your lordship, termination order was set aside by the honorable court, your lordship.
If he was drawn.
Yes, your lordship. It is
Where
in
is
the,
the copy?
it is in the record, in my affidavit, your lordship, at page 13.
In your affidavit.
Yes, your lordship.
Respond on. Paragraph number,
It's page 13, your lordship, annexure 4.
page 13. Disciplinary inquiry report.
Yes, and
So
proceeding,
inquiry was done.
yes. your
Yes,
lordship.
inquiry was done, my lord. Purported to be done, my lord. But whether I have been called or not, my lord. I have been questioned or I have been given this report or what is the charges, my lord? Article, what is the article of charges, my lord? And kindly, my lord, kindly see, my lord, last paragraph, what they have reasons. Second last para, my lord, in this inquiry, my lord. This is purported to be done, my lord. Should I not be given a chance, my lord, before this committee, my lord? So, my lord, I'll take my lord to the.
Now, all right, disciplinary action.
Yes, before taking any actions, I should be given chance, my lord, to say.
Yes. Now, what are your prayers now?
My prayer is, my lord, that this presence, my lord, termination order, interim order be set aside. And my lord, liberty, and earlier order also liberty has been given, my lord. And liberty was given to initiate.
Liberty was
Given.
But you have not challenged this disciplinary inquiry.
Because this was not punished, my lord.
DP.
This was not punished to me, my lord. And clearly I have stated in my paragraph itself, my lord, no disciplinary inquiry was done. This was by way of affidavit, they have not, my lord, just now they have filed, my lord. So, my lord, at the present, my lord, in petition, my lord, whether their actions is as per the procedure or not, my lord. Because in earlier judgments, my lord, clearly liberty was given to initiate any discipline as per the law, my lord. So
what's the date of this disciplinary inquiry report? 4/8.
4/8.
25/8/23.
25/8, my lord. Same day.
14 day, 14 years.
Same day, my lord. On that day itself, I have been terminated, my lord. So, question of my lord. How arbitrariness is there, my lord? Kindly see, my lord. And
Lordship,
this
may I-
completely disregard to this honorable.
You see, copy of the DP was not furnished to him. Number one. Second, suppose notice was not given.
Yes.
And then terminated.
Yes.
Without doing all this.
Yes, Lordship, earlier termination order was set aside, your Lordship, by this honorable court because he was terminated, though he was a regular employee, your Lordship, he was terminated by invoking wrong provision, your Lordship, by invoking Central Civil Service Temporary Service Rule. And that is why, your Lordship, this termination order was set aside by giving liberty to the respondent to initiate fresh proceeding, your Lordship.
But there is no such mention.
Lordship.
That second whose notice was served on the.
Yes, that is there, your Lordship. Though disciplinary proceeding was held, your Lordship, it is in the record, your Lordship. And after disciplinary proceeding, this report has been made, this report, your Lordship, disciplinary inquiry report. But, your Lordship, so-called notice, your Lordship, is not there in the record. So, your Lordship, my submission would be, your Lordship, to dispose this petition by giving liberty to initiate fresh proceeding by giving opportunity to the petitioner, your Lordship. will serve show cause notice, your lordship.
That is always there, my lord, in earlier judgment.
To hurriedly first order.
No, proceeding is there. It is in a record, your lordship. It is there.
You
Your
see, initially there
steps.
was first round of litigation.
Yes, your lordship.
Appropriate direction was given. Again, you have not complied with. You means.
No, we have complied with discipline. Your lordship, may kindly
But the
see the
procedural
inquiry.
was
5
not,
continuous years, your lordship. 5 continuous years she remained absent, your lordship, without any intimation to the authority, your lordship. Your lordship, may kindly see the report, your lordship.
Then in that case, what will happen to the termination order?
Termination order, your lordship, it may be set aside, your lordship, by giving liberty to the respondent again, your lordship, to initiate fresh disciplinary proceeding, your lordship, by giving opportunity to the
That is
petitioner,
up
your
to
lordship.
the department. No?
Her only grievances
drop
is
it,
that, your
yes.
lordship, that show cause notice was not given to her, your lordship.
This is, my lord, kind of harassment, my lord.
This
After
is not harassment, your
after-
lordship. Leniency, your lordship, has been given to her. 5
Clearly-
continuous years, your lordship, she remained absent
Clearly-
without intimation, your lordship.
Yes, that was a.
And
gross
that has
service
been
misconduct.
appreciated by the court,
It
earlier court
committed
also, your
gross
lordship.
misconduct, no doubt. But
Lordship.
procedure has to be observed. no?
Yes, your show cause notice. Otherwise, your lordship, as per the records, your lordship, records reveals that, your lordship, she is a habitual absentee, your lordship. From the very beginning of her service, your lordship, she remained absent just after joining her service. But leniency has been shown to her every time, your lordship, she joined without any medical fitness, medical certificate, your lordship. Her situation has been considered by the authority. After 5 continuous years, your lordship,
Then
kindly.
in case the termination order is set aside, then he has to be.
Reinstate, yes, your lordship, and show cause will initiate fresh proceeding by giving her opportunity, your lordship. With that, your lordship, order
that
liberty.
part is already
I
there,
am
my
not
lord.
in favor of the petitioner, mind you.
Yes, your lordship.
Because for 5 years.
5
he
continuous
remained
years,
absent.
and she's accepting that
Without
also.
even reporting, now so many grounds. are
Yes,
taken.
my lord. Yes, my lord. That part I agree, my lord. For that purpose, I should have been given opportunity, my lord, to answer because
That
that was
opportunity will
Also
give, your
did not
lordship.
inform the
my lord.
Yes, your
My lord. That
It should be disposed of.
yes, my lord.
Liberty may be given, your lordship. Liberty may
But
be
it's
given.
always there, my lord. It
But
is-
let
earlier judgment is there,
direction
my
may be
lord.
there to
And my lord,
for liberty, your lordship.
427 writ petition, my lord. 427. This is 437, my lord. Writ petition number. This is 437, and 427. I have challenged dash known, my lord.
Yes, silence.
Dash known order, my lord. It is similar, my lord. It will cover, my lord. If my lord pass the judgment, it will cover, my lord. Because here also dash known's order has been issued without so much notice, my lord.
Here, let me see.
Yes, ma'am. Interim order is, my lord, at page 23, my lord, annex 5.
What is the interim order?
Page 23, my lord.
23.
Yes, annex 5, my lord. This order is also annexed in earlier petition. This has been issued as per FR Rule 17A, my lord. And as per FR Rule 17A, before imposing this penalty, my lord, they should provide me a so-called notice, my lord. So here also, my lord, violation of natural justice, my lord.
Let it remain,
Lordship.
let it remain pending. This matter.
If this matter, my lord, if this is not stayed, my lord, then I will not put in service, my lord. Even if I pass the reinstatement, my lord, if this is not stayed, my lord, I will not in service, my lord. I will not get anything, my lord.
Stay.
All right.
Record is here, your lordship. Record is here.
Record is.
Yeah.
Give it. State. Simply state.
State, my lord. And my lord, just
For 5 years remain absent.
Yes, your lordship.
Intolerant.
And before that also, your
I
lordship.
know you guys. 5 years without service, but once salary, everything, all purposes, etc. etc.
Lordship.
my lord, salary, I was,
What contribution?
I did not get salary, my lord.
What contribution he has done to the state?
My lord,
Huh?
I was appointed in 1996.
Not-
I was because my lord, it was not
a
my,
procedural into procedural lapse.
it was by compulsion. I could not join that.
I would have dismissed him from service.
Yes, your lordship.
I mean, paid over fees. 5 years without work.
My lord, that was by compulsion, my lord. I was under treatment, my lord, or surgery.
But you did not inform. No?
Inform, my lord. It is also
Leave would have been granted then.
granted. That was granted. My lord will find
No.
in the record, my lord.
No,
He
no.
also granted, my lord.
Without
And
permission, your lordship.
some of the absence has been
It is there in the records, everything, your lordship.
Okay, ma'am. All right.
My please, Lordship. My lord, here, my lord, the IA which we have filed, my lord.
22, no?
Yes, please.
Let me see.
If IA 165 is taken up, my lord, very small matter, my lord.
What small matter?
My lord,
What is that? So small.
I'll just, my lord, it will take 2 minutes only, my lord.
I.
Yes,
On
165.
huh?
If the IA is disposed, the writ petition also will get disposed, my lord. That's why.
Settlement in which 4-member committee.
My lord,
Compensation.
yes, ma'am. Well, I'll just briefly highlight the facts of the matter, madam. Your lordship is aware the now our road is dilapidated condition because 415 high is being constructed. There falls my hotel, 3-star hotel, Benjamin Hotel, madam. What happened? For highway, my portion of my building has to be removed. For that, they issued notice and I filed writ petition. While the matter was pending before this honorable court, some developments took place. We found that, my lord, first of all, they made some assessment. Lordship will kindly take up the IA 165. I'll just show
Page
lordship.
number?
First of all, page number 18, I'll start, my lord.
No. This on IA.
IA 165.
165. Page number?
118, my lord.
18.
Yes. Annex 3, 18. So this was arrived, calculation was arrived, more than 2 crores. Then there was a negotiation between the parties, with the deputy commissioner saying this is too high. So they ultimately the negotiation came down to rupees 1 crore 13,70,996, page 20. This I obtained through RTI. And this document will suffice to dispose of this IA. Because this has not been objected, not been denied by the respondent. Now we leave that 2 crores, Maharaj. Page 20.
Hotel Benjamin is a RCC building.
Yes, Maharaj. Now,
and due to proposed pool and construction of the building is equal to the
a third paragraph, Maharaj.
Who assessed it? The Lord Deputy Commissioner.
This is, Maharaj, this is by the proposal by the Deputy Commissioner himself. But
this is detailed assessment.
E-filing, Maharaj. Yes, e-filing. Now, my lord, this is the government's own amount, but they arrived after negotiation. 1 crore 13,70,996 only.
Where it is serial number?
Page 20, Maharaj.
Page number?
20. Yes.
Achha, this
is the amount
for payment.
Yes, e-filing, my lord. This is through RTI we have obtained. Rupees 1 crore 13,70,996 only. This amount was arrived, my lord. This was sent to the government, my lord. Government approved. Fund is also available and is pending with the deputy commissioner. Now,
fund is also available.
Fund is, yes, my lord. My lord, kindly may take next page.
A sufficient fund at the disposal of DC for such
yes.
compensation.
Yes.
Claim.
Now the respondents are also not denied. Our simple prayers, my lord, direction may be passed to release that amount. That's all. Yes, sir, that's all. Nothing. And if that's order is passed, the main writ petition also gets disposed of, my lord. Because the main writ petition was that we should not be evicted, my lord. Where after compensation is given, my lord, that structures, photographs are already there, my lord. We have demolished the very highly valuable parts of the escalator and that lift, my lord. Externally.
Responsive.
The two conditions are given to petitioner that he has to demolish his structure, and for that 24
page number.
Page 5.
5
of affidavit.
Affidavit.
Yes.
5 to facilitate the speedy removal of structure only has already been released to the petitioner by the district administration. This is included in the that page number 20 or not? Or additional?
No, madam. No, just before that, but come to page 4 of that affidavit. They have not denied that amount. Yes, down below, madam.
Your deponent had obtained approval for the payment of any extra damage beyond 15 meters from the government amounting to rupees 1 crore 13 lakhs.
Yes, this is there, madam, last line.
The payment within ROW means?
Right of way, madam.
Right of?
Yes. Way.
Right of?
Way.
Way.
Yes.
Of 50 meters from the center of the road as directed by and any damage beyond 15 meters shall be paid after demolition.
That is demolition charge, madam, 24 lakhs. That we have annexed the photographs, we have already demolished. Lordship may kindly that petition right from page 24, madam.
That amount has already been
given, my lord. That is given to me for demolition. Yes, my lord.
Given to you.
Yes, madam. So that the portion that they have mentioned, we have
How
all
much was given?
the 24 lakhs which they have mentioned. Madam. We are not denying that.
Of rupees 24 lakh 66,288.
My lord, this man kindly it may not be, my lord, included in 1 crore. That is different, my lord.
That is not
No, that's a different one. This is a demolition charge.
paid. It is not included in the total compensation.
No, madam. That's a separate.
You are now on the assessment reports.
1 crore.
1 crore.
Yes, that they have not denied, my lord. In subsequent, the affidavit filed by respondent number 3, lordship, there also they have admitted this amount is there, my lord. Approved by the government. Government has approved, money is lying with the deputy commissioner. So only direction the deputy commissioner release that amount, that's all, my lord. It's not so complicated, my lord.
No complicated. It's not complicated.
Actually, condition was that, my lordship, in the first stage.
Don't mix up this
demolition and
demolition and this compensation.
Compensation actually after demolition of the entire structure.
They have said that demolition has already been taken.
Kindly see pictures, page 24.
Not picture.
What these things respondent is saying is
that has to be to demolition of the.
That has to be demolished first.
Demolished.
And photograph has to be submitted
After
before authority.
The amount will be paid.
Yes.
That's the time we have. That's why I've shown the pictures.
There's only some portion.
Is it stated in your
In IA itself is there, madam. Page 24, madam. 24 to 27. There was lift which was built outside of that building. That's one
So
of the
demolition you have already
done.
And thereafter assessment was made.
Assessment was separate, that is done separately. Assessment is for the loss I have incurred. A 3-star building has been demolished. It's not a small thing. That also, it was estimated was more than 2 crores. After negotiation, they are paying me half of that amount, 1 crore 13 lakhs on. That also they want to hold it back.
Anything more?
Then, I mean, on condition, in case, I mean, like the vacancy is released, he has to remove the entire structure.
No.
Within one.
No, that's not the condition,
That should be.
The entire
what I'm
building,
saying is-
how it can be released, demolished.
Some structure is yet to be distinguished.
That is not the terms.
Not the entire, I mean,
No,
some portion.
Portion.
That is
I've
already
always
marked.
shown, I have it's already there in the pictures.
No, you were saying you have already demolished.
Can you see
say
page
not
25?
demolished.
This is
No, that is photograph. No?
that's why Lordship can see now also. It's just on the way only.
Then I
Highway.
But authorities deny
spot and see.
Authorities saying, I mean, like,
he comes from that side only daily. He also has seen that structure.
I always
He practically has seen the big demolished. Now, why it should
No,
be?
I could have, but there is no clarity on this aspect. You were saying he is denying. That is
No, that
as of
subsequent
today.
affidavit.
Wait for 15 days. In the meantime, you file an additional affidavit.
No, that had time was given. Affidavit has already been filed,
But on this count. On this count. Additional affidavit.
So many affidavits have been filed, here.
But no further time will be granted.
Within pending.
So many continuous
Verify
orders.
the exact position. Let there be a report.
Actually, Malosip, this thing, authorities is saying, I mean, he has to demolish the structure
Yes.
first.
He
and take
says that
photograph.
demolition has already been done, but the entire building cannot be demolished.
Not the
because it
entire
is not
building.
covered.
Some of the portions are.
You
I
file
think,
an additional affidavit.
some of the portions are about Malosip. These
not
are
yet
yet to be demolished.
Wow.
Then
which-
take photograph and submit it to authority.
File an additional-
After that only.
This
On
2000,
a exact position.
2021 matter, several affidavits have been, they
Measure must be placed with transparently, no?
that's
Transparently.
why-
Okay, Malosip, what
Which
what I
specific-
suggest is,
Then you call him more personal appearance.
no, Malosip, this way what I'm suggesting is,
Things are not clear. You
If-
produce the file today.
this one,
Today at 2:30.
Malosip,
I'll see you.
what I'll suggest is,
Don't confuse.
this way, what my son will be, let the respondent number 3 release the compensation amount and the
Yeah.
petitioner
See, he
will
has
develop
challenged that, he has challenged for non-payment of the entire amount as assessed by the deputy commissioner.
yes,
this is admitted among
You are now creating confusion.
that has been approved by the government of course. Also.
Okay?
Only
Let
because
there
of
be release.
the simple, they in several affidavits they have admitted, madam. That simple order, madam.
Because after full application of mine, deputy commissioner has assessed the compensation.
And government has also approved, madam.
Where is the approval order?
In the same page. Page 21, madam.
Page number?
That starts from page 20.
Page number?
Page, my lord, starts from page 20. Now, kindly see, my lord, first page 22.
First page 22.
Yes.
Twenty-two of the read petition.
Yes. No, no, IA, man, IA.
Two.
It starts from page 20.
Starts from page 20.
This is, he is sent by.
Sufficient fund at the disposal of DC.
Yes. And it has been now, the Lordship will see page 23, last. It has, the file is written to Deputy Commissioner now. After, my lord, going up to.
For follow-up needful action as above.
Yes.
It is in our affidavit also.
Yes,
they also file affidavit.
That,
In our affidavit also. it is.
also they have admitted.
Yes.
Oblige, madam.
Will be pass.
Yes, oblige.
Self will again appreciate that.
Yes, otherwise was such a small.
Concern with your submission.
Yes, sir.
Submission.
Yes, sir.
Been pending since last 3 years.
Yes, sir.
Huh?
It is pending since
My lord,
last 3 years.
because affidavit
Then
after
you have
affidavit.
to pay interest there. Pay from your side.
Oblige, madam.
22, no? Order stays.
May I please? Instructions was called for. So my verbal instruction is that the formation cutting on that person has been already completed. During the time, the son of the one of the petitioner, he have no issue. He has given consent. After formation cutting, then they block the road by erecting a local fencing. And they are in flip-flops. Sometimes they say, approach authority, they will have a talk with the authority, and they keep on giving times to discuss the matters. So inter-HGB, even ADC authorities, they have agreed with the construction of road that portions. And during the time of construction, there was no any plantation. It was a vacant land.
You are representing whom?
I am representing
1, 2, 3.
My lord, let me check.
No, 1, 2, 3, madam.
I am for the RWD.
For 4, you are. 4, 5, 6.
I am for 1 and 2 only.
1 and 2.
I am for 1, then 3, 1 and 3.
1 and 3.
Executive.
2, madam.
Yes, sir.
2, madam. Then 4, 5, 6, 7.
I have
It's a
taken
private
justice steps, Lordship.
Justice service.
Yes, yes, I have filed affidavit also to that effect.
Notice. Served through dusty mode. On
Lordship.
respondents number 4 to 7.
Lordship, the
4
last.
to 7.
4 to 7, Lordship.
By the, where is the affidavit?
Affidavit I have filed, Lordship. It should be in the records. Affidavit was filed actual day for yesterday.
One extra copy of read petition, no. Concept for the prisoner has taken steps, no. Refusal of record, however, does not show. that the affidavit in support of
Lordship.
service of justice service
Yes.
has not been.
Lordship, I have filed affidavit, Lordship. It should be in the
It is
record.
not here. Is there any other file?
Yesterday only I have filed, Lordship.
No, it is
Actually
not
did for
tagged.
yesterday, but because of the time
But still, they are not available today, no?
this is a copy of the affidavit, Lordship.
But it
Yes.
is not tagged with the file. It is
Registry
not
may
even
be-
noted in the order sheet. Is it justice service? AST Tara?
Yes, no, Lordship Artani. Filed by Artani.
But the affidavit is in file, that is not on record. Registry to verify.
Lordship. In that case,
You
Lordship,
see, even if it is filed.
Yes.
Still there will be no final order because they have not appeared today.
yes, Lordship,
Give
but,
some time to them.
but Lordship, one thing, Lordship, I'm praying for interim, Lordship. That is why.
You bring this affidavit. Santosh? Affidavit, take with it. Go and bring. Justice service. It is not tagged with the file. And there is not even any office note.
So it will take it up after some time or when?
In the meantime, Lordship may hear my submissions, Lordship. Now, Lordship, the instruction which they have brought is only saying that some portion of the land has been, they tried to build and we have stopped and all that. The instruction does not say that the land does not belong to me. The instruction does not say that what I'm claiming is wrong, Lordship. Now, Lordship, if they are behaving in this way, Lordship, I will have no other option but to seek compensation, Lordship. I really did not want to do that, Lordship. If it is my land, just because some villagers have agreed, how come they can do things like this, Lordship? It is not in the instruction, Lordship. Lordship may say page 64, Lordship. Even though it is encroaching upon my land, I have agreed to sacrifice some portion of the land, Lordship, even not from the all DPR, but from a deviation also I have agreed, Lordship, which is touching upon some portion of my land, Lordship. There also they are not agreeing, Lordship. What kind of arbitrariness is this, Lordship? If they say it is not my land, I'm claiming unnecessarily, then I agree, Lordship.
You reported that that affidavit is not received.
Yesterday I have given, Lordship. There must have been some mistake, Lordship.
Inquiry in the office.
Otherwise, Lordship, I have already,
Then that cannot be acted upon. No?
of course, Lordship.
It is on the record.
But Lordship, the status quo, Lordship, may be granted today, Lordship.
My lord, otherwise, since when they put up the fence, we have not.
No,
done
they
anything.
cannot in any manner, they
They
cannot
have already
encroach
put
upon
up
my
a
land
fence.
like this.
Negotiation is going on with, they are approaching us for negotiation.
No, he is the
That
one
is
who's
my
saying that.
instruction.
He's the one who is saying they've called us for negotiation and we
That
have
is
not
my
come.
instruction.
Now, Lordship, if they can say that I am unnecessarily claiming upon some other person's land and saying this, then I can very well concede, Lordship. They cannot do this, Lordship.
But your affidavit is not received, no?
Lordship, actually it is received. There is some problem, it seems, Lordship. I have filed it, Lordship, And Lordship, basically, this is the original, Lordship. The receipt is also here, Lordship. There must have been some problem there, Lordship. Status quo, Lordship, may be given.
No, earlier it was not granted.
No.
This matter was hard.
Yes.
But
Instruction was sought.
Instruction was, interim was to be considered today, Lordship.
no, today
Yes.
the instructions are now received.
Yes.
These are not written, of course. Some verbal instructions are.
Yes,
received,
Lordship.
And you have not served notice.
Yes.
As per
Private parties is there.
office report.
In that case, Lordship, it may be taken up tomorrow, Lordship. I already have the receipt, Lordship.
Take status quo. As on today.
Obliged.
Third week of November. Next. I think detail.
Your Lordship, this matter pertains to the illegal termination of the petitioner from ITVP.
Like this. Third, 4th week of November then.
Actually, Your Lordship, this matter is pending for a long time, and he has been terminated from the service since 2013. So it's
So after vacation, we are also.
maybe given a fixed date, Your Lordship.
Do we fix it? Give me fix it. Third week. Fix it. 12. Then 12, 11.
Yeah.
Fixed. None appeals for the response.
What about you?
13. Break.
Well,
10 minutes. 10 minutes. Wait for 10 minutes.
Sorry for matter.
Hello.
1-3. The council, he is from Delhi.
What's the matter?
We are asking the equal privilege.
Huh?
We are the government employee. We are serving as a government employee, and our quarter is going to be evict. And we are asking the equal privilege which has been given to some other person. This is the matter. And Supreme Honorable Apex Court has been protected till 31st of October. This is the matter.
I appear in item 13 for the petitioner's merit.
Yes.
Is your lordship taking it up right now?
Is there some Supreme Court order is there?
The Supreme Court order is for has granted us protection from eviction till 31st of October. Now we are on a very different footing, my lords. Lordships will recall this is that matter where 7 government employees similarly situated to us, they have been offered private rented accommodation for a period of 1 year, my lord. And now when it comes to us, they say we do not have the funds. This is a different department. That is a different department. Therefore, because we do not have funds, we cannot issue that same direction to you. It may start, my lord, with your permission.
What's the view of the government?
The government has filed a counter affidavit, I believe. They say
no.
They say the private accommodation offered to the 7 government employees is by the Itanagar Smart City Development Corporation. In the case of the petitioners is under the Department of Housing. So I have basically challenged the violation of Article 14 vis-a-vis between the petitioners and the 7 government employees residing at Sector E. They have sought to justify the violations, saying that the 2 government departments are different. But Article 14 grants protection to the citizens. They have to establish whether we are differently placed than the 7 government employees who have been living at Sector E. cannot say that because there are two different government, two different colonies, therefore we'll treat you unequally. But may have just page 116A of the writ petition, my lord.
Page number
116A, my lord.
116A.
This is the privilege which has been given to the other party by the government.
It says 7 government employees who have to be evicted from their homes because a multi-story parking lot has to be constructed. They may be given alternate private rented accommodation for a period of 1 year. This is exactly what we are claiming. We are also government employees, state government employees, just like the 7 government employees, this particular page, my lord. We are also being
shifted to the private accommodation.
Please, my lord.
For 1 year.
A period of 1 year. They have been offered, my lord. I think some have chosen to go there, some have not chosen, my lord. But this offer is from the government. This proposal was from the government, my lord. Some have chosen, I believe, some have not chosen to accept this offer. My lord, we are also similarly situated. We have also been asked to evict, against which we filed an SLP in the Honorable Supreme Court, and the Supreme Court has granted us protection till 31st of October. After which, on which date we have to evict. My concern here is, my lord.
What is the copy of the order of the Honorable Supreme Court? Let me see.
Supreme Court order is page 111, 111, my lord.
11?
111.
No. Copy is enclosed or not?
Yes, my lord. Page 111.
Page number?
Page 111, 111.
111.
Yes. Operative person is at page 12.
Hey, read the operative portion, my lord. But the final paragraph, therefore, after hearing learned counsel for the parties and in the facts and circumstances of the case, we direct that the suit premises shall be vacated by the petitioners on or before 31st October 2023, subject to payment of rent and arrears thereof, if any. The petitioners shall hand over the vacant.
Shall not further create in third party wherein the petitioner shall file an usual article in this regard in 2 weeks from today. Is
File that undertaking, my lord. That undertaking is the very next page. We are ready to vacate, my lord. We are ready to vacate. Just provide us an alternate accommodation, just like you have provided the government employees who were living at Sector E. There's absolutely no classification, no differentiation between those government employees and the petitioners herein. For Article 14 is attracted, my lord.
yes. Respondent said.
Yes, my lord. This matter, my lord, was already dealt by the learned single judge in the earlier proceeding, and also a writ appeal was filed, and writ appeal was also considered by this honorable court. And thereafter, my lord, in the writ appeal also, there was no interference. Therefore, your lordship may kindly see the order passed in the writ appeal, page 140. 140, the order passed in the appeal. I'm just reading.
140.
Yes, paragraph 19 I'm reading.
140, paragraph 19, there is no doubt the right to
One-
life.
This is your past and writ appeal, man. Earlier person. There is no doubt that the rights to life includes right to shelter as observed by the Honorable Supreme Court. It's not a mere protection of life and a limb. It is home where he has opportunities to grow physically, mentally, intellectually, and spiritually. The right to shelter for therefore includes adequate living space, safe and decent structure, clean and decent surroundings, sufficient light, pure air, water, electricity, sanitation, and other civic amenities like roads, etc. So as to say, easy access to daily evacuation, the right to shelter before does not mean the mere right to roof over one's head, but right to all infrastructure necessary to enable them to live and develop as human beings. Of course, these are all subject to economic budgeting of the state. In the present day, government has already taken the decision to reconstruct the multi-story flats in the place of dilapidated and outlived government quarters where the respondent petitioner are presently staying. And as per the expert report, it poses a great risk and danger to occupants because of its deteriorated condition. Accordingly, respondent petitions have been requested to shift to the alternative accommodation situated at Lekhi village, Naharlagan. However, the respondent petitioners objected to same on the ground that same is not fit for human dwelling as there is no electricity and water connection in the said building. As noted above, there exists a policy for house rent allowance for those government employees who are eligible for rent-free government accommodation, but have not been provided with any rent-free government accommodation. Therefore, the government employees perhaps may not have right to insist on government accommodation if there is no government accommodation. It is not the case that the respondent petitions have been rendered homeless. Only the alternate accommodation at Lekhi village, Nagarlagan does not have electricity and water connection, which are part of basic amenities. In view of the discussion here, we do not find any reason to interfere with the direction for consideration of grievances or petitions passed by the single judge provide imperial order dated such as. However, we modified the order dated 29/7/2000 by directing the respondent authority to consider to provide the basic amenities, that is electricity and water in alternate accommodation at Lekhi village, Nahalagana, within a period of 2 weeks from date of receipt of certified copy of, or to provide house rent allowance as admissible to respondents, and thereafter the respondent petitioner directed to shift to the alternate accommodation at Lekhi village, Nahalagan within 7 days, so as to pave way for construction of multi-story flats for government employees. This was the order passed in the writ appeal one. Against this, they went to Honorable Supreme Court, and Supreme Court has given them date up to 31st October, which is over by almost 10 days now. Now, it is not that accommodation has not been given. And if the stand of our department is that housing, we don't have any alternate accommodation as on date, because all the house buildings that are full, and we don't have money to provide them rented houses. It has been done in the cases of the other people that is being done at E-sector Naharlagan. There what happened is, that is under the smart city project. Smart city project has a fund to accommodate those people for 1 year in a rented house. That's the only difference. We don't have money to pay money. That's the instruction I have.
They are seeking similar benefits.
No, that's why similar benefits cannot be
staying at E-sector.
Because government employee has the right to have HRA if they don't have accommodation. And this has already been expressed by Division Bench of this Honorable Court.
May I rebut, my lord? You just take 2 minutes, my lord.
That's the instruction I have, my lord. I have already placed my instruction before this Honorable Court in the last sitting also.
You see the operative portion of the Supreme Court's order.
Yes, please.
We direct that the suit premises shall be vacated by the petitioner on or before 31st of October 2023, subject to payment of rent and areas thereof, if any.
Yes.
The petitioner shall hand over the vacant possession of the suit premises to the respondent on or before 31st October 2023.
Yes.
And shall not part with or create any third party right therein. The petitioner shall file a usual undertaking in this regard within a period of 2 weeks from today, before the receipt is dated 30th of June 2023. The same terms and conditions. Similarly situated, no?
My lord.
Similarly situated case.
No, my lord, but project is totally different, my lord. The house that is where the case of that those people there under the smart city project, they are constructing parking lot under the smart city project, which is sponsored by Government of India. It cannot be equated in any manner.
Yes, any more?
I'll just take 2 minutes. Yes, sir.
Lordship, it Lordship see the read petition, Lordship. In read petition, Lordship, the petitions have been Lordship given accommodations at Lehi, Lordship. In read petitions, what was their contention? They don't want to go to their that particular accommodation because that accommodation is for the BPL beneficiaries, the below poverty line on category was the Lordship. They don't wanted to go there, Lordship. That is the case of the read petitioner, Lordship. Now, the Honorable single bench, Lordship, passed an order, Lordship, directing the authority to consider their representation at the same time to give accommodation to them, Lordship, to look for accommodation, Lordship. Now, under this circumstances, Lordship, in one hand, Lordship, the authority has been directed to consider the representation, and on the other hand, Lordship, again, the authority has been directed to go for looking for the accommodations for the petitioner, Lordship. Under this circumstance, Lordship, the state filed appeal before this Honorable Court, Lordship, division bench, Lordship. The Honorable Division Bench, as my friend has read, Lordship, directed them to sit at Lehi, Lordship. That may be noted, Lordship. They don't wanted to go to Lehi, but the Honorable Division Bench, Lordship, of this Honorable Court directed them to shift to the Lehi. And state has been directed to provide civil amenities here, Lordship. There is electricity, water, and accordingly, Lordship, those facilities have been already provided, Lordship. Now, when division bench of this Honorable Court has directed them to sit at Lehi, Lordship, on that base, this writ petition is maintainable or not, Lordship? This Honorable Court, sitting in a single bench, Lordship, whether we can go against that direction, Lordship? That's the one issue, Lordship, which needs to be, Lordship, examined by this Honorable Court, Lordship. And this writ petition itself is not maintainable. And against that direction, Lordship, the petitioner went to the Honorable Supreme Court, Lordship. Honorable Supreme Court, Lordship, upon the judgment of Division Bench, Lordship, Division Bench has directed them to shift, and Honorable Supreme Court, Lordship, upheld that. Upheld that means, Lordship, direction is there, Lordship, to sit at Lehi, Lordship. Now the petitioner has come before this Honorable Court by present writ petition. They don't want to go there again, Lordship. Can that issue be reopened again, Lordship? They want to go to rented house, Lordship. As some of the, Lordship, the cases have, employees have been provided in a rented house, Lordship. Now, Lordship, so far house rent and house rent allowances are concerned, Lordship. Every government employees are there entitled for the rent-free house accommodation, Lordship. In case if those infrastructure or accommodations are not available, lordship, then they are entitled for the house and allowances, lordship. There's a law, lordship. Now, lordship, when these people, lordship, this petitioner, when we propose to lordship reconstruct this particular building, lordship, then we, since this accommodation was there at Lekhi, we proposed them to sit there, lordship. That time this accommodation was available, lordship. Now all the accommodations have been exhausted. There is no infrastructure available to the government to accommodate any of the lordship, the employees. If their quota, due to old age, if their quota is to be dismantled, under this circumstance, lordship, we are providing the later cases, lordship, we are providing to the house rent, lordship. It doesn't mean that, lordship, they are entitled for the rent house, they cannot be accommodated to the available government, lordship, building. So my simple submission is that this writ petition is not maintainable. When division bench of this Honorable Court has directed them to sit at Lekhi, Honorable Supreme Court has upheld that. Now they have come before this Honorable Court by present writ petition. They don't want to go there at Lekhi. What is the case here, lordship? Case is that they don't want to go to the Lekhi. That's simple, lordship. So therefore, this writ petition is not maintainable and it may be dismissed first. That's all.
First.
May I, my lord? May I just take 2 minutes of your lordships?
By way of reply only. Please be very specific.
Please. The reason that I had to come in this writ petition again after a first round of litigation all the way till Supreme Court was because the state failed. It's whether failed or voluntarily, my lord, they did not produce this document. This page 116A. They knew they have already provided alternate private accommodation to some people. Yet, when the writ appeal was pending before this honorable court, the division bench, they chose not to produce this document, my lord. This document came to light us to the petitioners only when the Supreme Court case was going on, my lord. And your lordship is aware when no fresh document can be filed in the Supreme Court. Therefore, we had to file this writ petition. That is point number one. Point number two is they say we do not want to go to Lekhi village, my lord. But two reasons. First is it is below poverty line. I have not challenged that writ appeals order in this particular writ petition. I cannot. My only concern here is when you differentiate between two groups of people, it is the two groups of people that you have to differentiate between. You cannot differentiate saying these are two different departments. You have to say whether those 7 people belong to some different department of the government, which they do not. The petitioners and the 7 different people, they are absolutely similarly situated. They work for the same state government. They work on the almost same positions, the same departments. They have to bring out a classification saying petitioner's case is different because petitioners are differently situated. If they have not, they say we do not have any government accommodation apart from Lekhi village. We're not seeking any government accommodation. We are just seeking parity with number 116A, 7 people.
Okay. Judgment will be given.
Okay.
And this writ petition is for enforcement of the right of the villagers. This writ petition is for enforcement of the right of the villagers to cultivate in their own land. There is possibly a proposal, I'll take your lordship to the documents. There is possibly a proposal to widen or construct or develop a road, and before anything has been done under the Land Acquisition Act, The BRO, who is probably entrusted with the duty of constructing the road, has instructed the deputy commissioner that you pass an order not to make any construction on the right of way. And based on that, a section 133 CRPC order has been passed, prohibiting the villagers and prohibiting, in the name of this enforcement of this order, all the villagers to enter into their own land and cultivate. This is the basic grievance, my lord. Lordship, may kindly see page 21 first. The one page order, just read it, man. Slightly. Lordship, page 21. This is an order passed by the communication by Executive Engineer Civil Officer Commanding. Graf has written to the Deputy Commissioner, Upper Siang District. Subject is acquisition of land for construction / improvement of Dite Dime Miging Road to NHDL, specification from kilometer 53 to 92.250 in Upper Siang District of Arunachal Pradesh. Intimation of unauthorized construction activities. Kindly refer this office letter number so-and-so 21/7/2023 regarding needful action for publication of land acquisition notification for development of road Dite Dime Miging between kilometer 53 to 92.25 to National Highway double lane specifications, which is under process with the office of the DLRSO Inkyong. It is to bring to your notice that construction activities such as construction of cement concrete boundary walls and shelters with CGI sheets are being carried out at various locations by the public on the both sides of road with existing right of way, with the intention to claim compensation at the time of land acquisition, similar to what we observed in the road Inkyong to Moing. These unauthorized constructions are causing significant damage to the road surface, roadside drainage systems, and hill slopes, leading to instability of existing road formation. Additionally, these constructions have resulted in the blockage of existing drains and culverts, causing rainwater accumulation and further damage to the road surface. To provide a better understanding of the situation, several photographs illustrating the locations of these unauthorized constructions with respect to kilometer location is enclosed with this letter. Additionally, a fortnightly intimation report will be provided to your good self by this office about the construction activities being carried out on road sites. It is essential to recognize that these haphazard constructions pose a serious threat to the safety of road users and also result in increased financial burden on the government during the land acquisition process, considering the proposed right of way of 24 meters. Furthermore, it should be noted that construction of subject road to double lane specifications may take considerable amount of time. Until that time, the existing road will remain only primary means of transport in region. Therefore, it is essential to safeguard the existing road infrastructure from further damage. In the light of the above, it is requested to intervene to direct the office of DLRSO Inkyong to take immediate and necessary action to expedite the process for publication of land acquisition notification by state government for the development of the subject road. In the meantime, it is kindly requested to issue an executive order stipulating that no construction activities be permitted on either side of the subject road without obtaining the NOC from the Border Roads Organization or any other action deemed fit. This measure will ensure the immediate cessation of unauthorized construction activities and safeguard the existing road infrastructure. A prompt action in this matter, as it is of utmost importance for the preservation of our road infrastructure and to avoid the additional financial burden on the central government at the time of land acquisition.
This area, there is road, I think.
My lord.
Road is proposed to be equated.
Probably widen of 24 meters.
All right.
My lord.
Equate. So it is requested to publish notification.
Yes, now that notification has been published, page 24, madam.
24 is
Madam.
published.
Madam. This is under section 133 CRPC, madam. Page 24 is the time. Whereas it has been observed that construction activities such as construction of concrete, boundary wall, shelter, plantation, cultivation, etc., are being carried out at various locations by the public on the right of way with an intention to claim compensation at the time of land acquisition. And whereas land acquisition on the existing making road from so-and-so to so-and-so to develop the road to national highway double lane specification. And whereas such construction are causing significant damage to the road surface drainage and causing instability to the existing road formation. The existing road oils is the only primary means of transport in the region, hence it is felt that it is expedient to safeguard the existing road from the further. And now therefore I see so-and-so Deputy Commissioner cum District Commissioner under provisions of 133 CRPC do hereby prohibit all kinds of unauthorized constructions and plantation cultivation on the right of way of existing Ditedime Migging Road from 53 km to 92.25. Further, henceforth, any unauthorized constructions, plantation, or cultivation on the aforesaid right of way shall be viewed seriously and shall not be accounted in survey for compensation. This is the position, my lord.
Now, what is your prayer?
My prayer is, my lord, my grievance basically is taking advantage of this, well, assuming that ultimately notification comes for widening it to 24 meters, as has been said in it. 24 meters from the existing road will be, my lord, existing road is how much? Existing road is 1 feet. 3 meters. Supposing existing road is, my lord, 3 meters, that is about 10 feet, near about 10 feet. If it is to be made 24 meter, another 14 meter, my lord, 14 meter means on either side 7 meters. 7 meter means about 20 feet, my lord, from either side. Assuming that they ultimately they make it 20 feet on either side. Now we are saying our grievance here is, my lord, taking advantage of this order, our land inside, we are prevented from going into our land. We are prevented from taking steps for cultivation of seasonal plants, my lord. Can this be done? This is our grievance. So far, my lord, so far as these allegations are concerned that right of way, so nobody should make construct. We are not objecting for a moment. Yes, nobody should make any construction on the right of way. That will be 20 feet from the existing road. But my land inside the village, if you prevent, can you prevent this? We are not allowed to go into our land. This is our basic grievance. Now I'll show two things, my lord. Lordship knows that under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, the preliminary notification will come under section 18. Now, section 12, well, I'll not take your trouble, your lordship, just have a look at page section 11 once. Under the old act, it was section 4. Under the new act, it is section 11. Yes. Publication of preliminary notification and power of officers thereupon, whenever it appears to the appropriate government that land in any area is required or is likely to be required for any public purpose, a notification after referred as a preliminary notification to that effect, along with the details of the land to be acquired in rural and urban areas shall be published. I am not taking a lot further because there is no section 11 notification has not come as yet. Oh, not yet, my lord. This is the problem. My lord, assuming tomorrow they acquire land, and since it will be done by BRO, money has to be funded by BRO. Now, BRO, first of all, my lord, will have to get an approval from their concerned department. Your lordship is possibly aware of 2-3 writ petitions I have moved, my lord, where in the border areas of Arunachal Pradesh, my lord, 170 acres of land were taken up in 1962, initially by the Indian Army, thereafter by Assam Rifles. Now, when the question of payment of compensation came, they said no. Now, because of that Doklam incident, our strategically we do not require so much of land. We require only 10 acres of land. And rest of the land, my lord, from 60 to now, about 60 years, they have deprived the people and they have not paid any compensation because they are saying that strategically we have changed and now there is no approval from the central government. My lord, will you kindly see one thing. Section 3E of this act says who is the appropriate government. State government and collector, they are only the, my lord, acquiring authority. Section 3E, Lordship has got, my lord, appropriate government means in relation to acquisition of land situated within the territory of a state is the state government. Very well. Now, E5, Lordship may kindly see Roman 5. In relation to acquisition of land for the purpose of union, as may be specified by notification, the central government. Now, if the requiring authority is the central government, then it is the appropriate government is the central government. Now, from the central government, first of all, you must get as approval that see for acquisition of this land, we are requiring this much of money. This money should be sanctioned. Then only you can go ahead with the preliminary notification. They have not even published the preliminary notification. They are preventing, my lord. Now we'll kindly see section 12 for a moment. I'm just highlighting what is the legal position, my lord, in respect of land acquisition. 12 says preliminary survey of land and power of officers to carry out survey for the purposes of enabling the appropriate government to determine the extent of land to be acquired. It shall be lawful for any officer, either generally or specifically authorized by such government in this behalf and for these servants and workmen to enter upon, to dig, to do all necessary acts in respect of the land. I'm not reading the whole thing because once the appropriate government, that is the central government in this case, if they think that they are required, they will go inside. They will cause damage to the property. Then, now lastly, kindly see section 13. Payment of damage. The officer so authorized under section 12 shall at the time of entry under section 12 pay or tender payment of any damage caused, and in case of dispute as to sufficiency of amounts so paid or tendered, he shall and refer the dispute to the decision. So, central government may enter. Yes, we are making a survey. Since we have damage, we will pay compensation. Nothing has happened. What you are doing is, so far as the right of way is concerned, I am not objecting. Yes, right of way, even the deputy commissioner on his own can take some action. See, so some road is, some widening of the road will be going on. Later, around 20 feet, they will take for suggesting. Within 20 feet, you should not do anything. I have got no objection. Now, inside our village, which will not be required at all, even if the road is constructed, we are prevented. Can they prevent it, my lord? Now, Lord, will kindly see this order is passed on section 133. What is 133? I'm just here. And only because they are officers, they cannot do and at their whim pass any order they want.
No, the land is a private property.
Yes, my lord.
It belongs to the petitioners.
Petitioners.
You were constructing certain
road. You can do it. Once you acquire, my lord,
the land is yet to be notified to be acquired.
Yet to be notified. And now you are preventing.
Position.
My lord,
they want to exercise their right of access, then cultivation.
After section 11. After section 11 notification.
After section 11.
But now if you prevent me, my lord, what happens? Supposing my lord, government wants to acquire land, my land. Even if I have a construction, even if I have got my lord plantation, crop, whatever it is, they will acquire. I cannot claim that. I can only claim compensation. Jirat, your lord is aware, Jirat we call in Assam. I can claim Jirat, I can claim for land compensation, for building compensation. But in my agricultural land, which you are not going to acquire, you are preventing me from today from planting. And tomorrow, will you pay compensation for that? You will not pay. You will say, no, I have not acquired that.
Yes, madam. What do you say?
Well, just 1 second, my lord. 133 I am showing for a different purpose. 133 says, just for a minute, I'm sorry to trouble you, lordship. 133 says, conditional order for removal of nuisance. Whenever a district magistrate or subdivisional magistrate or any other executive magistrate specifically especially empowered in this behalf by the state government on receiving the report of a police officer, no report of police officer, or any other information, and taking such evidence, if any, as he thinks fit necessary, that any unlawful obstruction or nuisance should be removed from any public place. My private land is not your public place. How can a 133 notice can be issued, and I can be prevented from entering into my own land? And I have made specific statement in my writ petition, my lord. I want permission to go inside my own land, private land. This right of way, I am not going to do anything. I don't want to obstruct anything. I am not making any construction. Can they do it, my lord? 133, they can invoke the entire 133 rates, my lord, that nuisance, etc. Anything you do, and
based on report of the police officer.
Absolutely, man. And I am on my own private land, and these are seasonal. Not that I want to do something on the right of way so that tomorrow I can claim. I am on my twice in the year, my lord, I make this plantation. And how much of money I lose for not being able to plant, my lord? I have indicated. Will they take, my lord? Will they take the responsibility of paying me the compensation? They will not.
Your Lordship, this order is only a prohibitory order, Your Lordship, confining only to the right of way only, Your Lordship.
Whether any police report was obtained.
But
So,
DLRSO,
order under section 133.
Your Lordship, DLRSO has written to the DC, Your Lordship. DLRSO letter dated 3rd September 2023.
But can that be substituted now?
Yes, but it was observed that construction is going on the both side of the existing road, Your Lordship.
Exactly,
That is
exactly.
the
But
way.
where is police
case.
report?
Police
Where
report?
is police report?
It is not there, Your Lordship. There.
It is not there, but there is no reference to any police report. Executive order.
But this is only confining to the right of way. If they have to do anything to
Unpressed
in their
construction.
own land, Your Lordship, they have not prohibited that, Your Lordship.
I'm just
Cultivation and
suggesting
all.
one thing, my lord. On the right of way, even your lordship today will prevent us. I'm for that. I'm conceding, my lord. Right of way, we will not make anything, and we are not making also. But beyond that, in my private land, can they prevent me on the basis of this 133 order by the DFT Commission?
But in this order, Your Lordship, there is nothing mentioned about the private land, only right of way, Your Lordship.
Right of way to where?
My lord, as your lordship has indicated, even the right of way also, without section 11 notification, they cannot do anything. Let the notification come, and they see the specification also, they have not finalized as yet, whether it will be 24 feet or 20 feet. Order itself says specification yet to be finalized. Specifications which is under process.
And they have passed this circular also, Your Lordship, to all the stockholders or landowners to.
Madam, you file an affidavit.
Yes, Your Lordship.
attaching there with all the relevant documents.
Your Lordship.
That this order was legally passed. It is satisfied all the relevant provisions required before passing such an order.
Lordship.
You file an affidavit, until then maintain status quo will serve the purpose.
Lordship will make clear one thing, that right of way we do not also want to obstruct. Our
in respect, your right
of our private land, they should not prevent us from carrying out our cultivation activities in our private land.
Cultivate and you use the respective lands.
Private lands.
Without any constructions.
In the next state, Your Lordship.
Constructions.
Your Lordship, in the next state, Your Lordship, interim may be granted, Your Lordship, may be considered, Your
But
Lordship.
this is become margin.
Especially
If you
without
remove all the structures, etc., they will be having.
And my lord, problem is, my lord, this is the season. After that, my lord, we also don't need to go out.
The next returnable date, you file it.
Okay,
Status quo.
Lordship. Till the next returnable
My
date,
lord,
Your Lordship.
status quo order will not help. They will do.
No,
Stop.
they will not do. Status quo in respect of your right, those are mentioned in your petition.
Yes, sure.
Can be exercised.
Lord-
The next returnable date,
My
Your
Lordship will clarify one thing. In our private land, we should not be prevented.
Yes.
Yes.
But
On
that's
your
why-
private land.
That may be clarified.
Your prayer is issued by the respondent to against the petitioner, allow the petitioners to
Yeah.
cultivate and use their respective lands.
Private land, yes. Our private land.
Your private.
Mine. That may be clarified.
I'll clarify.
Lordship.
No prejudice will be caused to your.
Yes, even my lord, we also want the
See
road.
road condition, na? Naharlagan.
Yes.
Oh, how long it will take?
My lord, our alternative prayer is they will have to pay money to us. Because we also want road, my lord.
But there is no notification, na?
Till now, till now.
Still now. How
After
can,
notification, my lord, we'll have
how
to
can
write.
can you exercise this right under 133?
And my lord, this is
Had
still-
there been a notification,
Yes.
it would have been different.
Yes, ma'am. And our seasonal cultivation, my lord, after 1 month, that cultivation period will go.
I don't know how your cultivation will be affected if it is enforced. All right. Wait,
My lord.
I'm very sorry. Some urgent matter, tomorrow matter.
Today I will take up your matter, okay? Not tomorrow. Because tomorrow some important arguments are there.
Yeah.
Not on Friday, on last day, no.
On next day.
After vacation. We'll go to after vacation. Hmm. Only last day is very difficult to take state matters, na. But some people want some orders pass hurriedly.
My lord.
No. Okay, thank you.